So me and Suge, I done finally found my MobTies contract. Got a lawyer to look over it, but a lot of lawyers, like they don't really want to with it. They with it, but they don't really want to with it. I got a couple people that done reached out to me, and I just sent it to them, and I still don't trust this shit a whole lot. So me and Suge finally decided to do ChatGPT. So it's my first time doing using ChatGPT. I never used it. Everybody been encouraging me to try to use this, so I'm finna try to use it first time.
You should also put, is there any loopholes?
Have it been breached?
Like,
have this been...
No, ask it, is there any loopholes for you to get out of your contract?
Okay. Alright, so now, we go to Atlantic deal. I went through your contract and I'm going to break it down plain, no lawyer talk, so you can actually understand what's going on and what the power is. Contract overview. This is a deal between Atlantic Records Corporation, the label, MobTies Entertainment, artist company, artist Finesse2Tymes, Ricky Hamlin. This is a recording deal, profit share deal, not just a simple distribution. Exclusive deal, very important. The artist is locked in exclusively to Atlantic. Can't record for nobody else. Label controls all music during the contract. This is standard, but very restrictive. Length of contract. This is where labels win. Starts when deal is signed. First term until albums drop plus 10 months after. Then label has 3 options to extend. Meaning, label can keep him for up to 4 total periods. Artist does not, and especially if the artist had no proper legal advice. But this is not easy to win without a lawyer. So basically, if Jay Prince, the old man, told me don't get a lawyer. Mm-hmm. He told me, we ain't gonna go there. Advance and benefits could be used against you. They gave you cash, jewelry, truck, private plane, etc. Yeah, all that paid back. That means they'll argue you already got paid, so you owe delivery. So walking away could trigger recoupment claims or even lawsuits. Assignment clause, another trap. Transfer the contract to another label, company, anytime. So basically, they can sign their label over to anybody and I still be with them, basically. That's what they're saying. Can't transfer or escape, even the next deal, basically. That keeps you locked in, ownership changes. Okay, real talk. Yeah, that question right there is key, not just random. Short answer. If music was released through a real distributor, your easy loophole is probably gone. Why does it matter? In your contract, everything revolves around a distribution agreement. If they secured a qualified distributor like a real label, distribution pipeline, and release music commercially, then the contract locks in and extends automatically. The term becomes tied to their distribution deal. If music was released, here's what actually they usually means for you. You can't use the shopping period exit anymore. The contract likely auto extended. They now control master releases, your recording services. Basically, you're in an active deal phase. Okay? But don't get discouraged. You still got angles. Even if music drop, you can still look for what is real, qualified distributor.
Check this out. I can't believe y'all, bro. Y'all think this stuff is funny, but it's not. I moved off loyalty. I thought it was an honor to have Jay Prince, the old man, to be my manager. Y'all told me I didn't need a lawyer because all they do is F over people. Well, it looks like to me, y'all worse than lawyers. I'm asking as a man, can somebody please help buy me out this situation before I crash out and do something that get me a life sentence? Because the way I'm going out, it's guaranteed I'm not going. Die in the process. I'm not trying to be a bully, but this contract is one-sided. As F and I posted it all, let me out. Or I'm going to spend my entire life to bring y'all down. For all the MobTies street guys that got love for me and that I got love for, I hope this doesn't come between us. But finding out I don't own my masters, I agreed to a partnership, y'all. Got me good. Posting Atlantic contract next. Hashtag F the label. Finesse also posted his full contract with MobTies. Check this out. Or contained in or used in connection with the materials or the packaging or advertising for records or other products hereunder shall violate any law or infringe upon any common law or statutory rights of any other entity or person, including, without limitation, contractual rights, copyrights, trademarks, and rights of privacy or publicity. Without limiting the generality of the foregoing, you specifically represent and warrant that no selections recorded or to be recorded hereunder are subject to any re-recording restriction under any previous recording contract to which you may have been a party, and neither you nor any other person rendering services in connection with any materials is or will be a party to any contract which would in any way impair or interfere with the rights granted company hereunder. You hereby warrant and represent that you are not a resident of California. You shall indemnify and hold harmless company, distributor, and company and distributors' respective owners, officers, directors, affiliates, designees, and licensees from and against any losses and damages, including reasonable attorney's fees, arising out of any claim by any third party which is inconsistent with any warranty, representation, promise, or covenant herein made by you hereunder. This agreement constitutes the complete agreement of the parties with respect to the subject matter hereof and supersedes all prior or contemporaneous negotiations, promises, covenants, agreements, and representations of every kind or nature whatsoever with respect thereto, all of which have become merged and finally integrated into this agreement. No modification, amendment, waiver, termination, or discharge of this agreement shall be binding upon either party unless confirmed by a written instrument signed by each party. No waiver of any provision or any default under this agreement shall affect the rights of either party thereafter. Should any provision of this agreement be adjudicated by a court of competent jurisdiction as void, invalid, or inoperative, such decision shall not affect any other provision hereof, and the remainder of this agreement shall be effective as though such void, invalid, or inoperative provision had not been contained herein. This agreement shall be governed by and construed under the laws and judicial decisions of the state of New York. Claims, disputes, or disagreements which may arise out of the interpretation, performance, or breach of this agreement shall be submitted exclusively to the jurisdiction of the state or federal courts located in New York. New York, however, if company is sued or joined in any other court or forum in respect of any matter which may give rise to a claim by company, hereunder you consent to the jurisdiction of such court or forum over any such claim which may be asserted by company. You hereby acknowledge and agree that your services hereunder are unique and extraordinary, and that the loss by company of such services may cause company irreparable harm not adequately compensable at law, and that company shall be entitled to injunctive relief and / or other equitable relief in addition to company's other available rights and remedies to enforce the provisions of this agreement and company's rights hereunder. No failure by company to perform any of its obligations hereunder shall be deemed a material breach of this agreement until you give company written notice of its failure to perform, and such failure has not been corrected within 30 days from and after the service of such notice, or if such breach is not reasonably capable of being cured within such 30-day period, company does not commence to cure such breach within said time period, and proceed with reasonable diligence to complete the curing of such breach thereafter. Company may assign this agreement to any distributor, to any subsidiary, affiliated or controlling person, entity, or organization, or to any person, entity, or organization owning or acquiring a substantial portion of the stock or assets of company. Artist agrees to irrevocably and absolutely assign, convey, and set over to company's publishing designee, publisher, an undivided 50% interest in the worldwide copyright and all renewals and extensions thereof, and all other rights in and to each controlled composition. Publisher shall be the exclusive administrator of all rights in and to each such controlled composition, and it shall be entitled to exercise any and all rights with respect to the control, exploitation, and administration of the controlled composition, including without limitation the sole right to grant licensees, collect all income, and to use the name, approved likeness, and approved biographical material of each composer, lyricist, and songwriter hereunder in connection with each applicable controlled composition for the full term of copyright, including all renewals and extensions thereof, in and to each controlled composition, and without limiting the generality of the foregoing, BMI or ASCAP, the society, shall be authorized and directed to pay the publisher's share of performance of controlled compositions in the United States and Canada directly to publisher. Artist shall execute and deliver to publisher any documents, including without limitation, assignments of copyright which publisher may require to vest in publisher and / or his designees the copyright and other rights herein granted to publisher in respect of each controlled composition. If you shall fail to promptly execute such document, you hereby irrevocably grant to publisher a power of attorney to execute such document in your name. In the event that artist does not wish to enter into an exclusive co-publishing agreement with company upon execution of this agreement or during the initial contract period, then upon expiration of the initial contract period, if at any time thereafter, artist wishes to enter into an exclusive co-publishing and / or administration agreement, artist hereby grants to company or its designee an exclusive first negotiation / matching right to enter into worldwide publishing agreements, co-publishing administration with artist during the term. Artist A and company will negotiate diligently and in good faith for the purpose of and with mutual bona fide intention of entering into a mutually acceptable agreement, if and only if the material terms of such agreement are not confirmed in a writing acknowledged by the parties after such good faith negotiation, other than as result of your failure to comply with the provisions of this section, you shall then have the right to entertain third-party orders for such an agreement, provided, however, that neither you nor any person or entity on your behalf shall have the right to accept any such offer without first notifying one such third party of companies matching right hereunder with respect thereto, and 2, company of the identity of the offerer and the principal terms of such an offer. Company shall have the right, at company's sole election, exercisable by notice to you within 30 days thereafter the election period, to match the terms offered by such third party, it being understood and agreed that company shall not be required to match any term, for example, a keyman clause, which cannot be fulfilled as readily by one party as by another. In the event that company elects not to match such offer, or in the event that company fails to give such notice, you shall have the right to accept such third-party offer or any other offer which is more favorable to you than such third-party offer, on terms no less favorable to you than those contained in the third-party offer as presented to company for a period of 90 days following the expiration of the election period, following which the foregoing first negotiation / matching right shall reattach. A. You hereby warrant and represent that you have the full legal right, ability, and capacity to enter into and fully perform each of your obligations and covenants in this agreement, and to grant the rights granted to company hereunder, and that, by entering into this agreement and performing hereunder, neither you nor company, nor any distributor hereunder, nor any of companies or distributors, affiliates, designees, or licensees shall be violating the rights of any third party. You warrant and represent that neither the materials nor any of the contents thereof, nor the manufacture or sale of records or other products made from any materials, nor any other exploitation or use thereof, and no materials or other properties furnished by you and embodied, all necessary licenses, consents, and approvals, and other items required by company and distributor. A. Distribution agreement. Recording agreement with a distributor to which company grants the right to distribute records derived from the master recordings recorded under this agreement. Distributor, a record label or company. 1. Which is a parent or subsidiary of, or is affiliated with, that it shares common ownership with, one of the major branch distributors in the United States, which distributors are presently Sony Music, EMI, UMG, and WEA, or which is a parent or subsidiary of, or affiliated with, one of the indie distributors which provide national distribution, which indie distributors presently include, without limitation, RICO, RED, ADA, and E1, or 2, whose records are distributed in the United States by any such record label, company, or distributor. F. Master recordings or masters. Each and every recording of sound, whether or not coupled with a visual image, by any method and on any other substance or material, whether now or hereafter known, embodying artists' performances of musical compositions which have not previously been recorded by artist or others, it being understood that multiple versions, for example, different mixes or edits of the same musical composition or the same recording, will be deemed to be the same master for all purposes hereunder, which is used or useful in the recording. production, and / or manufacture of records. Person, any individual, corporation, partnership, association, or other organized group of persons or legal successors or representatives of the foregoing. A. Record or recordings. Any form of reproduction, distribution, transmission, or communication now or hereafter known of sound, alone or of sound together with visual images, which is manufactured, distributed, transmitted, or communicated primarily for home use, institutional use, for example, library or school, jukebox use, or use in means of transportation, including without limitation any computer-assisted media. A. Publishing. During the term prior to entering into negotiations with any third party other than us with respect to the publishing rights in the compositions and / or your writing services, individually and collectively, publishing rights, you shall first notify us that you would like to negotiate such an agreement. During the 60-day period after we receive such notice, you shall negotiate in good faith exclusively with us the terms of an agreement relating to your publishing rights. If, by the expiration of such 60-day period, no such agreement is reached with between you and us, you may negotiate with third parties an agreement with respect to the publishing rights, but you may not enter into an agreement with any third party unless you first, 1. Notify us in writing of the material terms of the proposed agreement pursuant to which such rights are to be granted, and the identities of all proposed parties to such agreement, third party offer, and I. Offer to enter into an agreement with us on the same material financial terms as the third party offer, matching right. If we do not accept the third party offer within 15 business days after we receive third party offer, you may then enter into the agreement set forth in the third party offer, provided that such agreement consummated upon the same or better terms for you and in the same form set forth in is the third party offer. The initial contract period. If artist desires to enter into an exclusive co-publishing agreement, then in consideration of $5,000 payable within 10 business days of written notice to company or within 30 business days of full execution of this agreement. If artist desires to enter into such exclusive co-publishing and administration agreement with company upon full execution of this agreement, then artist agrees as follows. Company with regards to business and administrative decisions, then company's decision shall control. A. Company shall pay to artist 70% of all net receipts, ancillary net receipts, in connection with any ancillary rights and all rights provided in paragraph 10. G. Ancillary net receipts shall be defined as all royalties, flat payments, or other compensation received by or credited to artist in connection with the services provided for in paragraph 12. G. Less any actual and legitimate costs or third-party payments relating thereto. Notwithstanding the foregoing, the company's share of ancillary net receipts, as defined above, shall not be diluted or reduced as a result of any ancillary income payable to any third parties pursuant to the distribution agreement, if any. A. Nothing contained in this paragraph shall be deemed to limit any of company's rights under this agreement. For the avoidance of doubt, artist shall not have the right to directly A. Indirectly enter into any agreement in connection with any of the services, activities, or rights described in this paragraph. 12 during the term except through the ancillary JV as artist furnishing company. The ancillary JV shall have the right to collect ancillary net receipts derived from any agreement entered during the term or substantially negotiated during the term and entered into within 4 months thereafter, following 6 years after termination of this agreement. Collection period. During the collection period, the principals of company shall remain the so-called key person contact with respect to any agreements entered into by the ancillary JV during the term or within 4 months thereafter. This paragraph 12 shall survive termination of this agreement. A. Assignment. Company may assign this agreement to a distributor or to any third party or to any subsidiary, affiliated controlling corporation, or to any person owning or acquiring a substantial portion of the stock or assets of company. Company may also assign its rights hereunder to any of its licensees to the extent necessary or advisable in company's sole discretion to implement the license granted. Artist may not assign this agreement or any of artist's rights hereunder, and any such purported assignment shall be void. A. Representations. Artist warrants and represents that I. Artist is authorized, empowered, and able to enter into and fully perform your obligations under this agreement. 1. Neither this agreement nor the fulfillment hereof by any party infringes upon the rights of any person. And 3. Artist has no knowledge of any claim or purported claim that may interfere with company's rights hereunder or create any liability on the part of company. A. Definitions. As used in this agreement, the following terms shall have the meaning set forth below. A. Advances. A prepayment of royalties which company may recoup from any monies to be paid or accrued to or on behalf of you under this agreement, including any amendment, modification, extension, or renewal, or any other agreement for your services. All monies paid to artist or on artist's behalf, including recording costs, shall constitute advances. A. Album shall consist of no less than 10 masters embodying artist performance and shall be at least 3 1/2 minutes in duration, with an aggregate duration of at least 35 minutes, unless company or distributor agrees to otherwise. A. Deliver or delivery. The actual receipt by company and distributor of fully mixed and edited master recordings, commercially and technically satisfactory to company and distributor and ready for companies and distributors' manufacture of records. And for advertising, promotional and commercial purposes, and general goodwill advertising. In the event company receives earnings solely in connection with advertising on the website, company shall pay artist 760% of all net income earned in connection with such revenue stream after all third-party costs and expenses are deducted. A. Company and any person authorized by company, each shall have the right to enter into separate agreements with mobile phone carriers to allow digital transmission of a download, including, without limitation, by means of a download or stream of a master or portion thereof, which may or may not be accompanied by artwork, images, polyphonic, MIDI, ringtones, voice messages, voice ringers, graphics, wallpaper, and or other materials, excluding masters. Mobile material delivered under the agreement along with all artwork, logos, images, names, and likeness related thereto to an end user's mobile telephone or personal, digital assistant, or other personal communication device. Artist agrees that company's rights shall include the right to exploit such masters and recordings via telephone, satellite, cable, point of sale manufacturing, transmission by wire or through the air, downloading, and any other methods now or hereafter known. Additionally, artist hereby licenses to company the right to reproduce each composition owned or controlled by you, which is embodied in the respective recordings for each of the contemplated uses described above. In consideration of such license, company shall pay you 70% of all net income received by company after deducting all costs and third-party payments relating thereto. Further, artist acknowledges that said mobile material is company's sole property. A. Artist hereby grants to company and its licensees the exclusive right throughout the territory to furnish artist services or to grant to third parties the rights, as applicable, during the term and for three months thereafter in connection with 1. Personal appearances, whether or not before an audience, and whether or not live and / or recorded for exhibition or broadcast, including without limitation tours. 2. Appearing, acting, or performing in television programs, video, films, whether musical or non-musical, or in live theater productions as an artist or as an actor, ILI. The exploitation, transmission, or distribution of recordings of performances by artists via wired or wireless systems, broadband, narrowband, or other internet, satellite, optical fiber, wire cable, or telephone. 4. The writing of literary or dramatic works, including, without limitation, fictional and non-fictional works, poems, newspaper, magazine, and other press articles and manuscripts, including, without limitation, television and film scripts and screenplays. 5. Exploiting artists' names, reputation, image, and other likenesses for any sponsorship, endorsement, or for any other advertising, commercial, or promotional purposes. And 6. Entertainment-related activities and services related to artists, other than merchandising as described above, including, without limitation, touring touring activities, touring merchandising income, special marketing arrangements, and strategic partnerships, etc. Ancillary rights. A. Company and artist hereby agree to form joint venture entity, hereinafter the ancillary JV, to exploit and manage the ancillary rights, and such rights shall be assigned by company to the ancillary JV. Company and artist shall jointly own the ancillary JV at the following percentages. 1. Artist 70%. 2. Company 30%. A. Notwithstanding the foregoing, company shall be the managing member of the ancillary JV and shall make and have final say on all administrative and business decisions with regards to the ancillary JV, including but not limited to the payment of bills and distributions of net income to artist and company. Artist shall have creative control with regards to the ancillary rights, and in the event of a dispute between artist and A. Grant of rights. A. As between company and artist, all master recordings, mobile material and artwork recorded and / or created hereunder from the inception of recording thereof, and all phonograph records manufactured therefrom shall be the sole property of company, solely for the purposes of any applicable copyright law. All such master recordings, mobile materials, and artwork shall be deemed works made for hire and owned by company. If, for any reason, such master recordings, mobile materials, and artwork are determined not to be works made for hire, then all rights, titles, and interest therein and thereto, including all copyrights therein, are hereby deemed irrevocably transferred to company, and artist hereby irrevocably appoints company as her attorney in fact for the purpose of executing such assignments in artist's name. B. Without limiting the generality of the foregoing, company and any person authorized by company shall have the unlimited right throughout the world to manufacture phonograph records and other derivatives by any method now or hereafter known, delivered from the master recordings made hereunder, and to sell, market, transfer, or otherwise deal in the same under any trademarks, names, and labels, or to refrain from such manufacture, sale, and / or dealing. A. Company and any person authorized by company, each shall have the right, and may grant to others the right, to reproduce, print, publish, or disseminate in any medium artist's name, approved portraits, approved pictures, approved likenesses, and approved biographical material concerning artist. Artist shall not authorize any party other than company to use artist's name or likeness. If artist does not approve material within 5 days, material will be deemed approved. A. Company shall have the exclusive right throughout the territory and in perpetuity, free from any claims whatsoever by you. 2. I establish and maintain a site or sites on the internet having the domain address and identification www.finesse2x.com or a similar designation based on or containing the artist's professional name or otherwise pertaining to any master, collectively the artist website, as company may select or otherwise designate. I select all materials, including but not limited to the artist's name, likeness, voice, and performance for use on or in connection with the artist website, collectively the website materials, or to refrain therefrom. I register the artist website and similar names selected by company in any and all territories with the appropriate entities and to secure any and all renewals and extensions thereof on your behalf. 4. Refer to the artist website as the official site relating to the artist or any master. 5. Exercise all of the rights set forth in 1, 2, 3, and 4 on or in connection with the site on a system which succeeds or is similar to the internet. Notwithstanding the foregoing, artist may have the right to retain one website so long as such website is maintained only for promotional and marketing purposes and no merchandise is sold. Such artist-controlled website must contain prominent links to company's website and the websites established and maintained under this subparagraph 12D. A. Company will have the right to use and allow others to use the website materials on or in connection with all media, including but not limited to the internet as designated by company, any websites owned or controlled by company, and any other websites. In the event the distribution agreement provides for escalations at gold and platinum sales, company shall pass through such favorable terms. Company shall use good faith efforts to secure such escalations in the distribution agreement. A. Foreign company shall pay to artist a royalty on the net sales of records derived from the masters equal to 50% of all royalties payable to company tour sales of albums in foreign territories pursuant to the distribution agreement. Royalties will be computed, calculated, and determined, except as expressly set forth herein, as provided in the distribution agreement. The royalties to artist hereunder shall include all royalties due artist and any third parties, including producers and mixers, who render services in connections with the masters recorded hereunder. C. Any royalties which company pays or causes to be paid to any such person shall be deducted from royalties payable to hereunder. A. Company shall use best efforts to cause distributor to account directly to artist for any royalties and / or advances becoming payable to artist pursuant to the distribution agreement via an irrevocable letter of direction. A. Mechanical royalties. Controlled compositions will be licensed to company at the rate equal to 87 1/2 100%, 1,087.5% of the minimum statutory rate in effect at the date of delivery or last date for timely delivery of the master recording concerned. The maximum aggregate mechanical royalties payable by company, regardless of the number of compositions contained on the applicable record, shall be 121 times the applicable rate set forth above for artist albums, 2 times such rate for singles, 3 times such rate for maxi singles, and 5 times such rate for extended play records, with respect to this paragraph. 6. In the event company secures more favorable terms with respect to this paragraph. 6. Company shall pass through such terms to artist. A. Merchandising. You hereby grant to company and company's licensees the exclusive right throughout the world to use and authorize the use of your name, approved portraits, pictures, likenesses, and biographical material, collectively name and likeness, either alone or in conjunction with other elements, in connection with the sale, lease, licensing, or other disposition of any merchandise uses, including without limitation any and all uses of artist's name and likeness in connection with sponsorships, endorsements, including your personal services in connection with any endorsements, tie-ins, retail, and connect tour merchandising, bounce back, merchandising, fan clubs, etc., whether or not in connection with master recordings hereunder. For the rights granted by you to company in this paragraph, company shall pay you a royalty of 8,050% of company's net royalty receipts derived from merchandising uses, after deducting all costs and third-party payments relating thereto, including, without limitation, all costs incurred by company which are attributable in whole or in part to the negotiation of licenses and other agreements for the uses of artist's name and likeness subject to this paragraph. Net merchandising monies. Notwithstanding the foregoing, artists shall have approval rights in connection with merchandising uses. However, such approval shall not be unreasonably withheld. A. Creative matters. All creative matters, including but not limited to selection of producers, material to be recorded, dates of rehearsal recording, shall be mutually approved by company and artist. However, in the event of a dispute, company's decision shall control. A. Logo. A logo designated by artist will appear on all record packaging, video chirons, and all advertisements in the U.S. placed and or controlled by company, subject to company's customary limitations. A. Accounting. Semi-annually. Within 60 days of company's receipt of statements from distributor, company will use reasonable efforts to cause distributor to account directly to artist. Company enters into a new distribution agreement. Notwithstanding the foregoing, in no event shall any new shopping period exceed 6 months in duration, and if company has not entered into a new distribution agreement as of the date which is 6 months after the distribution agreement end date, the 1 hereof shall be deemed to automatically expire, and all parties hereto shall be deemed to have fulfilled all of their obligations hereunder. 1. Advances/recording funds. A. Conditioned upon artist's full and faithful performance of all terms and conditions hereof, and upon company's receipt from distributor, company shall pay to artist the following net advances with respect to each album required to be recorded by artist hereunder from artist hereunder. LP 1 to 35, 70%. A. Net advances, as used in the preceding sentence, shall mean the gross advances actually received by company from distributor or such third party authorized by company to exploit the master recordings hereunder on an album, which are recoupable from any and all royalties, excluding mechanicals, payable to artist hereunder, less monies payable to third parties, including without limitation, reasonable legal fees incurred in securing any distribution agreement, including the advances and royalties payable to the individual producers of the masters or other artists which may perform on the masters, payments in connection with the exploitation of rights hereunder and otherwise, and any other bona fide costs or expenses incurred by company in connection with the production, promotion, or exploitation of the masters. A. Upon full execution of this agreement, company shall pay artist an execution advance of $40,000, $100,000, $1,040,000. Additionally, company will provide artist with a bulletproof truck, an allotment to purchase jewelry obtained for artist jewelry from the jeweler, and pick artist up from prison in a private plane. A. Legal advance, $15,000. The Okunu Law Group, PLLC. A. Royalties, conditioned upon artist's full and faithful performance of all the terms and conditions hereof. A. U.S. albums. Company shall pay to artist a royalty on the net sales of records derived from the masters equal to 50% of the net royalties payable to company pursuant to the distribution agreement on top-line sales of U.S. albums through normal retie channels, but in no event less than the following: 1,714%, 184.5%, 185%, LP1, LP2, LP3, LP 4 to 5, 16%. Contrary contained in this agreement. A. Each contract period, SIX, shall be coextensive with the then current period of the distribution agreement or successor agreement, as defined below, as applicable, plussing. A. Additional 30 days. B. From time to time, company shall have the unrestricted right, but not the obligation, at company's election, to conform any one or more provisions, for example, definitions, reserves, free goods, etc., of this agreement to the distribution agreement. And C. You hereby agree to duly execute any letters of inducement that may be required pursuant to the distribution agreement. A. Artist hereby grants to company 24 separate, consecutive, and irrevocable options to extend the term for one additional contract period, consisting of one album per option. In the event that the distribution agreement, if any, provides for contract periods of longer duration, then the provisions of the applicable distribution agreement shall prevail. Company will be deemed to have automatically exercised its option to extend the term for the first additional contract period as of the date of execution and delivery of the distribution agreement. Each option of company for any subsequent additional contract period will be deemed automatically exercised by company as of the end of the then current contract period, unless company gives you a written notice of company's election not to exercise its option. In the event company enters into a distribution agreement, the term herein shall be coterminous with such distribution agreement. Each contract period shall be coterminous and coextensive with the then current period of the distribution agreement, plus an additional 30 days. A. Notwithstanding anything to the contrary herein, you shall have the right to terminate the term of this agreement by giving written notice thereof to company at any time after the expiration of the period which commonees as of the date on which you deliver to us a reasonable number of technically and commercially satisfactory demi resertings, demos, to enable us to commence shopping for a distribution agreement, or you first perform show ESEs during the term for a potential distributor, whichever is earlier and expires on the date 6 months thereafter, the shopping period, unless prior to the date of your such notice, company has entered into an agreement with a qualified distributor as defined below for the distribution of records hereunder, or company has substantially negotiated the material provisions of such an agreement, and such agreement is entered into within 4 months after such 6-month period. Such qualified distributor shall be sometimes referred to as the distributor, and such agreement shall be sometimes referred to as the distribution agreement. Upon sua termination, if any, all parties shall be deemed to have fulfilled all of their obligations hereunder. As used herein, the term qualified distributor means a record company or distribution company. A. which is a parent or subsidiary of, or is affiliated with, that is, shares common ownership with, one of the major record label in the United States, which distributors are presently Sony Music Entertainment, Universal Music Group, and Warner Music Group, or which is a parent or subsidiary of, or affiliated with, one of the so-called indie distributors, which provide national distribution, which indie distributors presently include, without limitation, Human Resources, RED, ADA, Ingrooves, and L Music. B, whose records are distributed in the United States by any such record company or distribution company, or C, which is mutually approved by company and you. 1. Notwithstanding anything to the contrary herein, in the event that the term of any distribution agreement expires or is terminated prior to the expiration of the term hereof, the then current period hereof shall be extended, and the running of all time periods set forth in this agreement shall be suspended for the duration of the time period, the new shopping period, which begins as of the date of such expiration or termination of the term of such distribution agreement, the distribution agreement end date, and continues through and until the date that